as a consumer may see that they can attach on many trade lines on one dispute, but when you're going to sue the credit reporting agency or the furnisher, it's very difficult to evaluate where they messed up when all of those disputes are mixed on one letter. But if you have provided one letter for one dispute for one trade line, it's very clear whether, or to get the responsibility of the credit reporting agencies when they're attempting to they're doing their reinvestigations. And so it's really important to understand the potential damages that a consumer may have. The Fair Credit Reporting Act is very different from the Fair Debt Collection Practices Act. In the Fair Debt Collection Practices Act, there is strict liability. So what that means is if the conduct occurred, if the debt collector sent a letter or violated the law in any way, they're automatically on the hook for the potential violation, which is up to $1,000 plus their attorney's fees. In the Fair Credit Reporting Act, it's very different. So in the Fair Credit Reporting Act, there's a materiality aspect to damages. And what that means is you need to understand whether you have actual damages or if you're just pushing a statutory damages theory. So if you have actual damages under the Fair Credit Reporting Act, you can push either a negligence theory, which requires actual damages, or you push a reckless or a willful non-compliance theory, and you could push statutory damages plus punitive damages. Actual damages, or under a negligence theory, requires a consumer to be actually harmed if they have been denied credit, if they have been, let's say, even if they were approved for credit, but instead of being charged 2% interest, they're being charged 5% interest. That 3% is an actual damage. If you have sent a dispute and as a result of the credit reporting agency still verifying inaccurate information, you have been denied credit, you have suffered actual damages. On the other hand, there is statutory damages and punitive damages if you push a recklessness or a willful non-compliance with the Fair Credit Reporting Act theory, with the Fair Credit Reporting Act. And what does this mean? This means that you provided multiple disputes. You gave the credit reporting agency an opportunity to correct the reporting multiple times, and each time they failed to follow reasonable procedures to ensure maximum possible accuracy. The same applies for furnishers. The more disputes that you have, you'll be able to establish statutory plus punitive damages. Punitive damages are kind of like punishment type damages. And it really depends on how many disputes you've sent if you are able to, or trying to establish punitive damages. But for the most part, this is a very complex legal analysis that takes place when you're trying to do an analysis about damage assessment. And this is one of the reasons why we make sure that we have an objective inaccuracy when we're going to be filing suit, because we want to make sure that we're able to show on paper that the credit reporting agencies really screwed this up when you had an opportunity to provide them with notice. And again, it's really important to understand the client's goals and expectations. The consumer has a lot of rights under the Fair Credit Reporting Act, and it's really important to understand those rights and also to understand the client's expectations. Some people may be applying for credit over the next 2 months, and they need something to be rectified very quickly. Other people have already suffered their damage and now want to collect, and they're okay with being a little more patient. It's really important to understand the specific client's goals and expectations so that we can prepare them accordingly, and also that we can provide them the maximum benefits that they're seeking. And our firm, we use Clio in order to really manage how we communicate with our clients and make sure we're keeping our clients